Congratulations on your new invention. You've probably done your homework and you've been advised to protect your invention by applying for a patent. And you probably also realize that one of the major markets for you is the US. And so you've decided to apply for a US patent. But then one thing that's on your mind is, how do I go about this process, and how do I not just file for a patent but ensure that I get it granted, and what are the steps involved in getting the patent granted? So don't worry anymore, because in this blog I'm going to explain the entire process to you in 10 easy steps. The process of obtaining a patent is called patent prosecution, and there are specific professionals who are qualified to help you obtain patents, and these people are called patent agents or patent attorneys. But before you hire your patent attorney, it's important that you should at least know what you're getting into. So without further ado, let's get into the 10 steps to obtain a US patent. The first step is to conduct a patentability search. Did you know that in order to be eligible for a patent, your invention has to be new and also has to be non-obvious to a person of average skill in the same field that the invention relates to? And these two things, novelty and non-obviousness, are measured with respect to prior art. Prior art is all the information that's available to the public at the time of applying for your patent application. Now, if you're sure after conducting the search that your invention is novel and non-obviousness, you can move to the next step, which is to prepare and file a patent application. Now, your patent application can be filed first either as a provisional patent application or as a non-provisional patent application. The non-provisional patent application must not only include a detailed description and drawings, but also claims, which defines the scope of protection that you're eligible for through your patent application. Please keep in mind, your patent application must describe your invention in sufficient detail to enable a person of average skill to implement your invention without undue experimentation. The third step is to submit an oath and declaration which is signed by all the inventors, and also submit a power of attorney to authorize your US patent agent to represent you before the US Patent Office. Please keep in mind that in this oath and declaration, you'll be submitting to the Patent Office that it's your duty that you will be disclosing any prior art which is relevant to the patentability of your invention. The fourth step is to execute and record an assignment agreement. Now, if the applicant is a company, then the applicant would have to prove that they have the rights to apply for the patent. How can you do that? By signing an agreement which transfers the ownership from the inventors to the applicant or the assignee. And this assignment agreement has to be also recorded with the US Patent Office. Now let's move to the fifth step, which is to pay the filing, search and examination fees. And these fees are determined based on your entity status. The US Patent Office has got three different types of entities: a large entity, small entity, and micro entity. Now, a small entity has to pay only 50% of the fees of a large entity, and a micro entity has to pay only 25% of the fees of a large entity. So you have to figure out whether you qualify for a small entity or micro entity, and according to that, you've got to pay the fees. The sixth step is to submit an information disclosure statement. Now, as I mentioned earlier, you have to sign this declaration which says that you have to disclose any prior art that's relevant to the patentability of your invention to the US Patent Office. So any prior art that you are aware of, you have to fill up this information disclosure statement and submit it to the US Patent Office. Now let's move to the seventh step. If you've done all these things, your patent application will be typically published within 18 months from your priority date, which is the earliest filing date. Now, subsequently, a few months down the line, you'll get your first office action. An office action is an examination report where the US Patent Examiner conducts their own search and due diligence, and they raise objections on the basis of novelty, non-obviousness, and on the basis of whether your invention is sufficiently described. So you have to respond to this office action within 3 months typically. And if you don't respond to the office action within even 6 months, your patent application will get abandoned. So this is where the expertise of a patent attorney is very important and critical. Now, after you respond to this office action, there's a chance that the US Patent Office may issue a second office action. Now, your first office action is called a non-final office action, and the second office action, typically, if you have amended your claims in the first office action, would result in a final rejection or a final office action. Now, if you want to amend your claims once again while responding to this second office action, then you will typically have to file a request for continued examination along with the corresponding fee. And once you do that, then the patent office will once again go back and send you yet another office action, which will be a third office action. But at any point during this process, the patent office can agree and say that all the objections have been overcome, in which case the patent office will issue what is called as a notice of allowance. Now, once you get this notice of allowance, all you have to do is to pay this issue fee. And once you do that, you will get an issued patent, a granted patent, and a patent number. So after you get a granted patent, that's not enough. You still have to maintain your patent application, and you have to pay maintenance fees at the end of the 4th year, the 8th year, or the 12th year, and so on. If you fail to pay these maintenance fees on time, your patent application and your patent rights will lapse. So that's it, folks. With this, I've summed up 10 easy steps for you to get a US patent, and now you're ready to make the most of your valuable intangible asset. If you would like to know more about how you can work with a patent professional to get your US patent granted, shoot me an email at ip@myipstrategy.com. See you soon.